All right, and then this is People v. Mary Ann Burgess. File 25-7036FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Blaine County Prosecutor.
No, Nigel here from Miss Burgess, who appears in person to my right in custody.
All right, we're here for sentencing the jail contraband habitual third with a 10-year maximum, some misdemeanors as well. Guidelines for scored at 0 to 13 months. If you have a chance to review the report and recommendations.
Have your honor.
Any additions, corrections, or scoring challenges?
One correction just as to credit time. It has for credit time through June 25th. She did become incarcerated again on July 30th, today's date. So that would be, I think, 14 additional days.
Okay, for a total of 56 then?
Correct.
Okay. All right. Any scoring challenges?
No, your honor. And she advises everything else that's correct.
Okay, Ms. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. So Ms. Burgess comes before the court at 37 years of age. She is, although she's had a recent sort of slip up here, getting into recovery court, does advise that she's absolutely committed to continuing the program. She thinks this is going to be great for her and her small child. She is employable, and I think employed when she's out of custody. I think she's got a bright future going forward as long as she can stay on the straight path here. She is committed to doing that. I think she's going to be moving out of the residence, which she was staying, which I think had some contributing factors here to why she's appearing in front of the court today in orange. We are going to ask to have her admitted into the recovery court program. It sounds like all parties involved, at least that I've been able to speak to this morning, are on board with that. She's very much on board with that still. And so that's what we want the court to do today, is just to adopt the party sentencing agreement for Sheboygan County Recovery Court. I don't believe that Ms. Burgess wants to make a statement today, but I would, I guess, also highlight for her on her behalf that although she had this slip up, it seems like she was very honest about what was going on and pretty forthcoming. I don't have any other information that indicates otherwise, at least. So I think that she's going to continue to be a good candidate and is committed to doing this right. Thank you.
Okay, thank you. Ms. Burgess, you don't have to tell me anything today, and if you don't, if you choose not to do that, I don't hold that against you at all. But you are allowed to say anything if you wish. Is there anything you want to say or no?
No, Your Honor.
Ms. Goodrich, any recommendations?
Your Honor, I continue to be in agreement with recovery court for Ms. Burgess.
All right, Ms. Burgess, if you want to please stand for the first sentence. Ms. Burgess, you're 37 now. You've got 2 prior felonies, 5 prior misdemeanors. I've had you on probation before, and it went very badly because of your failure to comply. So in this case, I think that even though these guidelines are not, they're at 0 to 13, this would be unlikely to be a prison case for you. We normally like to take prison presumptive cases into recovery court and reserve the spots for that. But the extent of your substance abuse struggles and the lack of progress on regular probation made us think that your application into recovery court was appropriate, that you need a more intensive probation. You did have some issues starting out, but if you're honest with what's going on, I think we'll do everything we can to try to help you navigate these struggles that you've had. But I need you to know you can't just do things the way you want to do them, which is how you and I have operated that way for a while. I've had you on probation before, and that hasn't seemed to bother you to do what you want, go where you want, do the things you want, ignore the things you want. Me being a judge with a probationary order over your head hasn't seemed to affect your behavior at all. If that continues, you're not going to finish this program. Honestly, only about half the people that enter the program graduate from it. The ones that do are the ones that honestly want to do it for themselves. But those are the only ones that make it across. So only you know if you're in that category. I hope you are. In this case, you were driving while high and gave the police a fake name. You didn't have a driver's license, and then when you got to the jail, you had some drugs you were gonna take with you into the jail. So that's all, bad behavior that puts you and other people at risk out in the community, on the roads and in the jail. Even with the 0 to 13, you would certainly be getting some jail from me. But I think that you're appropriate for this treatment court program. Based on my review of the file and the pre-sentence report, I find under the applicable statute that Ms. Burgess is or was dependent on or abusing drugs or alcohol, and she's an appropriate candidate for participation in a treatment court program. I find that she understands the consequences of entering into that program and has agreed to comply with its requirements. I find that Ms. Burgess is not a violent offender, and she doesn't pose an unwarranted or substantial risk to the safety of the public or any individual based on the information available to me from our pre-sentence screening and pre-sentence report. Therefore, I find that she is appropriate for treatment court, so I will sentence her accordingly to probation on the felony charge for a term of 30 months, subject to the terms and conditions listed on page 3 and 4 of the pre-sentence report. That includes all the conditions on there. The principal term is that you comply with and graduate from the Sheboygan Recovery Court program. I'll also order that you serve on that charge as well as on the misdemeanor charges, 56 days in jail, and give you credit for 56 days previously served. There is on this judgment going to be state costs totaling $218, crime victims assessment of $130, court costs of $350, a $600 recovery court participation fee, and $141.08 for an OUAL reimbursement. That is a sentence within the advisory guidelines. Ms. Burgess, if you wish to appeal, you can do so by filing an application. If you wanted a lawyer, you'd have to ask us within 6 months. We're going to hand you a piece of paper explaining that process and ask you to initial one copy for us, so we have a record we gave it to you. The other one is for you to fill out if you want to take an appeal. You should get the paperwork done to get you out today, and then you need to stop by and see Nicole today. You have any questions for me?
No, Your Honor.
Okay,
Thank you for the opportunity.
Okay, and I'll see you tomorrow morning in recovery.
Okay.
That hearing had a little bit of everything. People versus Ann Burgess wasn't a high drama showdown. It was a sentencing where the question wasn't whether she'd be punished, but whether recovery court might give her a real chance to turn things around. Judge Aaron J. Gauthier set the tone with a mix of stern reminders and cautious optimism. He didn't sugarcoat her record: 2 prior felonies, 5 misdemeanors, and a track record of blowing off probation. In his words, she's had a habit of doing what she wants when she wants, and ignoring court orders, but instead of shutting the door, he leaned into accountability with an option: the structured, demanding environment of recovery court. Sometimes silence speaks just as much as words. Her attorney's advocacy filled the gap. Prosecutor Melissa Goodrich stayed consistent with the theme of rehabilitation. She voiced no objection and supported recovery court placement, which helped pave the way for a unified front. That's notable. Prosecutors don't always back treatment options, especially when prior probation has failed. But here, there was agreement that a stricter. Only about half of participants graduate, he noted, and only those truly doing it for themselves succeed. His message was equal parts warning and encouragement. The system can provide structure, but the drive has to come from her. In the end, Burgess received 30 months of probation tied to successful completion of recovery court, 56 days of jail time already credited, and a stack of fines and fees. More importantly, she walked out with an opportunity to rebuild, not guaranteed, but possible. Judge Gauthier struck the balance between accountability and hope, signaling that while past behavior weighs heavily, the court still believes in second, and sometimes third, chances when defendants show signs of wanting real change. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.